morning, good morning, good morning, and happy Wednesday. Say, there is a quorum present. That is exciting. Do I have a motion to approve the minutes from February 28th?
You have a motion.
Representative Albright? Thank you. He moves the approval of the minutes from February 28th. Any additions, corrections, or additions? No? Okay. Well, hearing none, all those in favor say aye.
Aye.
All right. Those opposed say same side. All right. The motion prevails and the minutes are approved. Okay, so we have a packed agenda today, so I need you guys to be brief in your presentations and questions. And before we go here, just to set the stage for here we go presentation. You guys, I've been going through, what is going on here? All right, the place is falling apart. I have been going through some of the horror stories, and this is way beyond somebody walking an infant in a stroller and getting in trouble for it. Let's just read a couple of these citations I was reading about. Let's see here. We've got, yes, children were exposed to a hazard. Now you may be thinking, what is that hazard? It is absolutely awful. During the visit, the DHS licensor observed a staff person drinking hot coffee in the toddler room. Ladies and gentlemen, if I don't have my hot coffee in my hand, people may not want to be around me most days, okay? Especially when we're working with children. Hot coffee in the hand. And that person was written up and cited and had cited, my gosh, I can't speak today, cited, and they had to correct the order immediately and submit written documentation within 30 days of receipt of the letter detailing how compliance had been achieved. Let's see, another fun one is area used by the children were not in good repair. That paint was chipped on the half door that separates the two preschool children's classrooms. An outlet cover plate was broken in the school preschool classroom. The corrective action ordered, correct immediately, and submit written documentation within 30 days detailing how compliance had been received. And let's see here, one more fun one. Elizabeth, why don't you come on up while I read this last one. The violation. Although the diaper changing procedures that had been developed in consultation with a health consultant were posted in the diaper changing area, the corner of the diapering procedure was torn off and missing. Because the corner was torn off, not all of the diapering procedure was posted. And that person was, of course, had to post a complete diapering procedure, blah, 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 another written up. So, Elizabeth, go ahead.
Madam Chair, members of the committee, my name is Elizabeth Bangard from Here We Grow Early Childhood Center, and this is my colleague.
Hi, I'm Haley Bloward.
Since last October, as I mentioned, I know I've graciously been given 5 minutes. We began compiling data because for years providers have been sharing their stories regarding ridiculous citations and overreaching. And 300 in, the story is not looking that great. Unfortunately, I could not compile family providers because they're, as you know, not publicly listed yet. However, I know their struggle is similar. This report is over 3,000 pages long, so I could not print it. However, what I did print was the 1 page of reconsiderations. Sorry, I'm super nervous. Reconsiderations that were given notice to, and the 2 where someone requested reconsideration were denied. So we're talking about 1 out of 3,000 some pages out of only 300 licenses. There's a 2-page report, and we are calling this the Joy Initiative because we would like to bring joy back to our profession. There was a period of time where we had to stop doing this research because it became so dark that we did not want to go to work anymore. Everything within our building became a hazard. Things that I didn't even know could be a hazard. There were kids building near the wall with blocks, and I considered asking them to please move their block tower because I didn't want chipped paint. This is impacting the lives of children, and from my perspective, this is why there's a childcare crisis, this overreaching. And what's further irritating is while we're talking about trying to be a team, this public data was on a website and no one reviewed it for years. And when we met with the Department of Human Services, they said it would be tedious. It is absolutely tedious. We have full-time jobs and we copied and pasted it verbatim off the licensing website. It literally made me question whether or not I want to do this anymore. And I still, sitting here, don't know if I want to. So to all of our parents at Here We Grow watching this, that doesn't mean I'm closing, but we're getting near that point. So in our analysis, there's the first tab is our license file. The second tab is all of the citations, and then there are 6 following tabs where we broke out by statute and rule, which are the most we feel overreaching. And I think the main point is we don't know what any of these different thresholds are for conditional licenses. You could have a repeat violation for something under a hazard or health and safety that's from 7 or 8 years ago, and the health and safety one time could have been someone drinking coffee, and the next time it could have been a door that was left open, and then the third time it could have been prickly grass. When does it end? So we're here to break the silence and end the childcare crisis. Thank you.
Thank you, Ms. Bangert. Is there anyone else in the audience that wishes to testify?
Madam Chair, can we be provided with some of this information?
As she said, Representative Flanagan, it is 3,000 pages long. It is listed on the committee website.
Thank you.
Thank you very much. Ms. Dancy, did you have something?
Thank you, Madam Chair. I was just going to ask you, the document that she had, just the first page, is that something that we could have a look at?
This should be in your package. All right, members, sometimes it's helpful before we start asking questions to go through our package.
Madam Chair,
Yeah.
the document that we have, at least on a superficial glance, looks different than the document that she has.
All right. Yep.
Is this just maybe a summary of?
That is posted on the committee website.
Okay.
Yep, the full
Okay.
document.
If it's on the website, we can find it too. Thank you.
All right, so next up on the bill, we have Representative Peterson with House File 3205. And Representative Peterson, as she makes her way up, she moves that House File 3205 be approved and recommended to the Committee on Health and Human Services Reform. Representative Peterson, a brief explanation of your bill.
Thank you, Madam Chair and members. House File 3205 is childcare assistance, about childcare assistance, and this helps families access and afford stable, nurturing care environments for their children while parents strive for success at work. In turn, it's critical to developing a robust workforce now and in the future. All the concepts in this bill were heard last year as part of a bigger package of CCAP reforms. While some of these very important provisions passed, thanks to the work of Representative Franson and members of this committee, others remain, and this bill contains a subset of them. 1305 helps homeless families, and it removes barriers for families using the program and updates badly outdated provider reimbursement rates. As you may recall, they're based on 25% of 2011 rates. These changes would create greater stability in the lives of children and families, improve predictability in the business of providers, and help to ensure that more providers can serve CCAP families without taking a financial loss. I'd like to ask Melinda Hugdahl, representing the Kids Can't Wait Coalition, to walk through the bill now in more detail. Madam Chair.
All right, thank you. So Representative Peterson, I understand you have a testifier on the bill?
I do. Thank you, Madam Chair. Melinda Hugdahl from Legal Aid on behalf of the Kids Can't Wait Coalition. Madam Chair, if it's fine with you, I think in the interest of time and your direction to kind of be brief, Since these were concepts heard last year, I'll kind of remind folks what they do. We made some minor changes from the provisions from last year, and I'm happy to walk through that level of detail if you want it, but in the interest of time, I think I'll just go through what the bill is unless someone wants me to do something different. So Section 1 of the bill is the definition of a homeless person. This matches up with the federal definition that's used, and this relates to later provisions in the bill that talk about homeless families accessing the Child Care Assistance Program. Section 2 of the bill addresses families who are receiving MFIP, which is our cash assistance program, and are ready to move off of MFIP and onto what's called transition year childcare, which is that transition bridge program. What happens now is if you don't receive MFIP for 3 months, you can't get your childcare in transition year. You may get a job that makes you ineligible for MFIP, but you can't actually take the childcare with you, which just puts people in a loop back on MFIP. So the Section 2 change is it reduces that from 3 months to 1 month. So if you're on MFIP for a month and you get a job and you're ready to move on, this will allow you to keep that childcare as you move into the transition year program. So it's intended to help families move off of MFIP after as early as 1 month. Section 3 of the bill is really the steps about processing applications for homeless families. There are 2 pieces within the bill. One is to expedite applications within 5 days. Usually it's 30 for families who are homeless. The other is about making sure that they can access the program while they're getting verifications and work activities together. But this is the section in Section 3 about processing the applications. So they have to do that within 5 days. If they need information to do that, the parents will fill out the application. If something's blank or confusing, the county has 5 days to request that information. If they're eligible, that approval goes out within 5 days. If on the face of the application they don't look like they're eligible, that is a 30-day window, and that's kind of gets these families going. They get up to 3 months then to provide all the paperwork. As you know, a lot of families experiencing homelessness have a lot of instability. They might not have access to the paperwork that they need. We're giving them time to get on the program, to get these kids into stable environments for childcare, and allow those parents to further stabilize their own situation, look for work opportunities, and have the kids beginning into that process. So that is what Section 3 effectively does. Section 4 deals with the portability pool, which addresses cases when families move from county to county. Currently, what happens with the portability pool is that when you go to the new county, you have to notify both counties, the county you're leaving and the county that you're getting to, that you're moving. And you get child care assistance through the portability pool for 6 months. But if you move to a county with a waiting list longer than that, you're off in 6 months and you're just off of child care assistance. There's no magic to the 6 months other than the statute says so. So the section of the bill changes it so parents can move from county to county. That portability pool can be used to extend them so they keep child care, because usually they're moving because they've taken a new job. So we want to keep that employment going. It also just changes that they notify the old county they're moving from, because when the old county puts it on the system, both counties know about it. So the case is transferred at the county level and just cleaning that process up. So it's easier for families and it's easier for counties. Section 5 is, again, that second piece about the homeless family provisions, which is talking about that they can get up to 60 hours of child care for 3 months while they are getting their verification paperwork together and also looking for employment and everything or education. If they don't do that within the 3 months, at the end of that period, their eligibility ends. So that's the piece for homeless families. Section 6 is the provider rate increase, and I know this has been a big issue. We are required to increase our rates, which are still set at 2011 levels, even though we've done market surveys since then. So this would update it to always be the most current market rate that is done, and hopefully that will help from the provider side. Right now, they are getting such low reimbursement on these cases that it makes it even more difficult to serve these families, even though there are a lot of providers who would like to. It just makes it tough. So this will help hopefully with that piece of the puzzle too. And I think that is the bill.
All right, thank you. Is there anyone in the audience that wishes to testify on the bill? Members, any discussion? Representative Albright.
Thank you, Madam Chair. Ms. Hogdahl, on Section 3, we're talking about some modifications that affect the counties. And I'm just wondering, or confirming the participation of the counties in the changes that were made under this section.
Madam Chair and Representative Albright.
Ms. Hudell?
This section, we have worked on, it was a concept that was out last year too in the bill. We haven't heard anything from the counties that there are concerns. And I talked to the department folks yesterday and they haven't heard any issues with this that I know of. So if I hear anything, I'll be sure and let obviously Representative Peterson know too. But to date, we haven't heard anything. And last year, there weren't any substantive objections to these concepts. And it moved to Representative Dean's committee. I think it was really fiscal issues.
Madam Chair, I have just one further question.
Yes, Representative Albright.
For either the author of the bill or to Ms. Hogdahl, in Section 5, Subdivision 3, where you're extending the number of hours of child care assistance per service period to 3 months, is there an inference that the county would be responsible for additional dollars to that, or is that just a coordination with the state?
Madam Chair and Representative
Hogdahl?
Albright, no. What happens is if they are coming in and they're homeless and they're MFIP eligible, but they'd be on MFIP childcare, which is forecasted from the state. If they are coming in somehow as basic sliding fee eligible but are homeless and meet this definition, that would still be subject to the appropriations that the counties currently have. So this isn't intended to put the counties in a position where they're expending extra funds, is my understanding.
Thank you.
Thank you, Representative Albright. All right, is that all? Representative Peterson, do you have any comments?
No, thank you, Madam Chair, and thank you to this committee, and I hope we can move forward to the next step.
All right, well, Representative Peterson renews her motion that House File 3205 be approved and recommended to the Committee on Health and Human Services Reform. Those in favor of the motion say aye.
Aye.
Those opposed, same sign. All right, the motion prevails, and House File 3205 is approved and recommended to the Committee on Health and Human Services Reform. Next up, we have Representative Quam. The bill on the agenda is House File 2780, and Representative Quam moves House File 2780 be approved and recommended to the Committee on Health and Human Services Reform. Representative Quam, could you please give a brief description of your bill?
Thank you, Madam Chair. And this bill came about because of attending a meeting that the department and child care providers were at. I've actually been attending those for years, and so it comes from several. But there's a lot of confusion and consternation around the changes. And so the first part of it, I had several daycare providers say, the cost of repetitively doing the background checks. If I have someone that's a junior or senior in high school, I don't want to turn right around and pay again. And they asked, can you have the option to choose that if you have an older child, that then you can opt in for the 5-year, background. And I said, because it's optional and doesn't force anyone to make that decision, I have no problem with including that in the bill. The second section, it became evident that there's not a notification that, they say we're going to destroy this biometric data and we're not going to keep it. But I asked, do you notify? And they said no. And I thought, well, when you notify you pass your background check, you should give notification that you followed through and destroyed it. And then the third section, direct the commissioner for a unified background check. Frankly, if we have people that are working with our children, then we ought to have consistency. And by doing this, we have people that maybe are substitute teachers at a school. They subbed to give daycare providers vacation. And by having it unified, then they go through the process once, because it's up at the state level. The entities can call and, is there an active background check and that they passed? And they can say yes. And it saves repetitive cost, time, and hassle. And so this is to try and see how we could implement that. It's not really changing the status quo yet, but let's look at doing it smarter. And that's, a summary of the bill.
Thank you, Representative Quam. I understand that there's some testifiers on this bill. All right, Ms. Seidel, would you please make your way up to the testifying stand? And if there's anyone else that wishes to testify on the bill, please come forward as well. Thank you. Ms. Seidel, please state your name for the record.
Thank you, Madam Chair and members of the committee. My name is Julie Seidel, and I'm the Public Policy Director for MACCP, and also I've been a child care provider in Anoka County for 15 years. House File 2780, in the current way it's written, we cannot support this bill. With some amendments to address our concerns, we could offer our support here. We appreciate Representative Quam's attention to the matter of disclosure. To date, we have been unsuccessful obtaining full disclosure regarding, regarding the enhanced fingerprint background studies. However, the current language gives child care providers a false sense of security, as it assures them their prints will not be retained by DHS, the BCA, or DPS, but does not require DHS to disclose that our prints will be retained by the FBI. We have offered some proposed amendments and thank Representative Quam for his willingness to work through language with us to ensure full disclosure regarding how prints will be used, who will have access to our data, and where they will be retained. We've also offered a proposed amendment that would require the BCA to request removal of our prints from the FBI's NGI database once we no longer are subjected to background studies. It is our understanding that without this request made by the BCA, our prints will be retained until we're 110 or been dead for 7 years and stored in the same database as convicted criminals. It's also important to us that parents receive this full disclosure prior to deciding whether or not their children should be subjected to these invasive fingerprint studies. So we have offered possible amendment for requiring this. Last, while we don't have language to propose at this time, we do have concerns that if fingerprint background studies are an option, DHS or county licensors will pressure providers to choose this or fail to mention it's optional, resulting in children being subjected to fingerprinting by default. We look forward to working with Representative Quam and DHS on this language so that we can protect the rights of our children and providers.
Thank you, Ms. Seidel, for your thoughts on this issue. It's probably the #1 issue that I've heard since session adjourned last year, so thank you. Representative Quam.
Thank you, Madam Chair and members. You should see in your packet amendment draft being considered, because it did not, I didn't receive this in time, and we weren't able to get it available in time. It's not before this committee, but would now be available. And this is the language that was came to us to try and cover that notification. And you can read through the proposed language. And so there will be an amendment to address this concern at the main committee.
All right, Representative Quam. Members, is there any discussion? All right. Any final comments, Representative Quam, or was that it?
Madam Chair, just to sum up, that all of this came from daycare providers at a public meeting that came forward.
All right, well, thank you, child care providers, for bringing forward your thoughts. Representative Quam renews his motion that House File 2780 be approved and recommended to the Committee on Health and Human Services Reform. All those in favor, say aye. Aye. Those opposed, same sign. Motion prevails. House File 2780 is approved and recommended to the Committee on Health and Human Services Reform. Next up, Representative Quam has House File 3015, and he moves that House File 3015 be approved and recommended to the Committee on Health and Human Services Reform. Representative Quam, please give a description of your bill.
Thank you, Madam Chair and members. Basically, because we now have the online and the availability for, people to see the history and et cetera of correction orders, the daycare providers felt it was a redundancy. Plus, they, even if it was a correction order that was corrected, as was examples were given at the beginning of the committee meeting, they feel as if having them on the wall for years, it doesn't make for a good, climate and feeling. So there were two possible ways of handling this. The revisor came back with, and I dropped two bills so that all the parties could look at, and this was the consensus choice of the best way to handle it. So that's why this bill is here.
Thank you, Representative Quam. I do know that you are very thorough in the work that you do and like to get the opinion of all parties, so I appreciate that. I understand that you have testifiers on the bill. Reggie Wagner from DHS.
Madam Chair, if needed.
All right.
Madam
Rich-
Chair,
yep.
members of the committee, Regina Wagner, DHS Licensing Division. Very briefly to the bill, the department is in support of this bill and appreciated the opportunity to be able to weigh in. We were at some of those same meetings. This has come up. The last week I testified about many of the hearings that meetings that we are having around the state. This was a very common one that providers raised. And as Representative Quam mentioned, because of new requirements from the federal reauthorization that require online posting of monitoring results, and the fact that we have built an electronic checklist tool that is allowing us for the first time to capture the information at that county correction order level. We previously had not posted, as others have mentioned, the county correction order information. It stayed at that county level. So I think as the kind of technology advances, as the requirements move forward, and just as background, this requirement is in statute. It's not in rule. Historically, this came not from the department, but from legislators several years ago, before we even began to post any of our information online, and wanted families to have that information about the correction order history at a location. And I think, where it reflects as technology is moving forward, how people get their information now. And this was a very significant pain point that providers brought up. And so the department, is here to support this as we continue to move our childcare system forward and our information forward.
All right. Well, thank you. Members, any discussion? Any final comments, Representative Quam?
It's nice to see teamwork and everybody in agreement. This is sometimes a tough subject, but I think we've got peace in the valley.
Well, I appreciate the fact that you're excited to also take care of this crisis that's facing Minnesota. So thank you, Representative Quam. Representative Quam renews his motion that House File 3015 be approved and recommended to the Committee on Health and Human Services Reform. All those in favor say aye.
Aye.
Those opposed, same sign. Motion prevails, and House File 3015 is approved and recommended to the Committee on Health and Human Services Reform.
Next bill on the agenda is House File 3253. Representative Franson moves House File 3253 to be approved and recommended to the Committee on Health and Human Services Reform. Representative Franson, to your bill.
All right, thank you, Representative Albright, or Chair Albright, sorry. This is a bill to exempt family and center-based childcare providers from the positive supports rule, which went into effect August 2015. This rule is being applied to childcare programs based on its initial intent, training required, and additional administrative burden put on these private programs. Last year, it wasn't last year, the fall before, I co-chaired the task force on access to affordable childcare with Senator Wickland, and there was a lot of testimony from childcare providers about this rule, and the task force also looked into the applicability of the rule for childcare settings as one of its regulatory recommendations. And so to testify on this bill, we've heard this situation last year. The bill was before us. I'm going to have my testifier take over.
I see you do have a testifier. Welcome to the committee. If you could please introduce yourself for the committee and then proceed with your testimony.
Thank you, Mr. Chair, members of the committee. My name is Claire Sanford, and I represent the Minnesota Childcare Association, which is an association of about 250 licensed center-based providers around the state. And instead of a bunch of prepared remarks, because I know you heard a lot about this on behalf of our association last week, and as Representative Franson said, the year before as well, I thought I'd take this time just to walk through quickly how this year's bill is different from last year's and then take questions. This year's bill is also, as it was last year, a full exemption from the positive supports rule requirements for both licensed family and center-based child care providers. But in addition, we've added some things to this bill just to clarify and further show that we are completely in support of the intent of the positive supports rule. We are completely in support of protections for those with disabilities. We just do not feel that this rule is workable for childcare. In fact, at a HHS hearing last year, Deputy Commissioner Chuck Johnson testified that the positive supports rule is not a good fit for childcare. So this bill, as I said, is an exemption from the positive supports rule, but we added additional language this year, just clarifying and confirming the protections already in place for children with disabilities in child care licensing language. So this just kind of reiterates what's already in child care licensing language, that when serving children with disabilities, child care providers are required to follow the individual education plan, if the child has one, and the individual child care plan. And those are both plans that are developed in consultation with the school district, with the parents, with other service providers, with physicians, et cetera, anyone serving that child, to make sure that we are providing what that child needs based on their disability within the child care environment. And it also adds language taken from the positive supports rule to explicitly prohibit child care providers from using the prohibited restraints and procedures such as seclusion and deprivation and things like that. A lot of that's already prohibited in child care licensing language, but just to show that we want no part in doing anything to children with disabilities or any children that are harmful, we want to add language from the positive supports rule to child care licensing language, just as another show of strength that, yes, child care providers are prohibited from using all of these procedures that are prohibited in the positive supports rule.
Representative Franson, do you have any other testifiers to this bill?
Not that I'm aware of, Mr. Chair.
Is there anyone in the audience that would
Oh.
wish to testify? All right. Welcome back to the committee. If you could state your name for the record and proceed with your testimony.
Julie Seidel from Minnesota Association of Child Care Professionals. And I just wanted to state that MACCP strongly supports House File 3253, the bill to exempt child care providers from the positive support rule. Last session, we did provide the legislature with copies of the lawsuit settlement agreement showing that positive support rule itself is not a requirement of the settlement. And we also provided the legislature with documentation that Rule 40 Committee only expanded the recommendations to other DHS licensed programs at the request of DHS. I brought these documents with me today. If you'd like to read over the 200 pages, I have them marked for you. And it's not applicable to the clients that we have, and it would create such a hardship for family child care providers. We are already prohibited from using abusive techniques But we'd like to thank Representative Franson for bringing this up again and hope that the committee will support this. Thank you.
Is there anyone else in the audience wishing to testify to the bill? Anyone else in the audience? Anyone else in the audience? Parliamentary procedure 3 times. That being said, members, any discussion to the bill? Final comments, Representative Franson.
Nope, hopefully this will be the year that we can pass this, put it into law, so we can move on to even more exciting issues within the child care.
That said,
Industry.
Representative Franson renews her motion that House File 3253 be approved and recommended to the Committee on Health and Human Services Reform. Those in favor signify by saying aye.
Aye.
Same sign. Motion prevails. House File 3015 is approved and recommended to the Committee on Health and Human Services Reform. Members, that concludes our work for today in committee. Our next meeting is next Wednesday, the 14th.
I'm sorry, I misunderstood the question about testifying on that one. Can I speak up? I'm Kim Leopold, I am on the
Oh,
yeah,
agenda. I'm really sorry. I misunderstood. I thought I was gonna be called on my own. I'm sorry.
Ms. Liebel, just to clarify, we have voted on the bill, so
That's okay.
the information that you provide would be informational only.
Great, that's all it was anyway. Thank you.
Come on up.
Hi.
Hi.
Welcome to the committee. If
Sorry.
you could introduce yourself to the committee and then provide your testimony.
My name is Kim Leopold. I am a board member of the Association for Minnesota Family Child Care Licensors. It does say on here Dakota County. I'm not representing Dakota County today. I'm representing the group of licensors. The group covers statewide. We all meet. It's a group of licensing workers throughout the entire state. I was just going to touch on each of the bills that were proposed here today. In response to 3205, we do not have concerns about this bill as a group. In response to 2780, Section 1, Subdivision 1A, we do not have concerns about that subdivision. In response to 2780, Section 3, we feel more information is needed. There are different things about the transferability of the background studies. Is it a state thing? Is it if I get my fingerprints done in Ramsey County, can they transfer? Things like that. In response to HF 3015, we do not have specific concerns about this bill, and as Ms. Wagner from DHS spoke of, eventually so much of that stuff is going to be on a website that parents can access, because one of the requirements of the block grant money is that it makes provider and program information more accessible to help parents make informed decisions about childcare. And I do have to, I have to raise a couple of questions, not questions, just statements. I know that you were joking about the coffee, but we literally had a burn in Dakota County last week from a child grabbing the coffee off of the stove, and they had to go to Regions Burn Unit because of that. So I know that I know we all need our coffee, but there are reasons why this is happening. I think we need to get back to about the children in care. Also, I know it's not on the table, but I don't know when it will be. The ALJ recommendations being the final word. There have been instances where DHS has changed their order to reflect the ALJ's recommendation, as well as provider settlement agreements. However, the ALJs are not specialized in childcare, and their recommendations have not been in the best interest of children. And I'm just going to read one that I brought. It is from a provider who admitted to slapping a child, because a 4-year-old, because she was stressed out and was worried she was protecting herself. The core of the department's claim is that a slap to a 4-year-old child's face in April of this year, 6 years after other inappropriate methods of behavior guidance were used, reveals an imminent risk of harm to the health and safety or rights of persons served by the program. In the view of the administrative law judge, that claim is overstated. The department has not shown reasonable cause to believe that Daycare program presents imminent risks of harm to health and safety or rights of the children under care. This is a public document. I'm just not going to say this provider's name here. There is a risk that this provider might slap another child or address poor behavior by children under care in an inappropriate way, but that risk is not imminent in the way that our case law has construed this term. Even if one were to compress together the various correction orders in this case as if they were close in time, the conclusion would be the same. A slap plus the inappropriate use of a spray bottle, pepper, soap, sand, and separating a child at a table so as to guide behavior does not present risks of serious injury. That's what an ALJ said about a provider who admitted to slapping a child. Lastly, I listened. I wasn't able to be here last week. I listened. It's so concerning how upset so many people are about what's going on with the state of childcare in our state, the affordability, what's happening from DHS. I mean, we feel it too. Don't get me wrong. Our workload has doubled. But I would like the committee to know that a licensing worker's job, as with providers, is in conjunction with DHS, and our job is to provide safe and loving care for the communities and the children in the communities and the families in the communities. And as with providers, there can be discrepancies in interpretations and differences. We still have to figure out how to make it work best for the children in the care and the families that are bringing their children to care. I would like to suggest that instead of pointing out all the past transgressions, that we need to talk and work with each other to move forward. AMFCCL, I specifically, I guess, am willing to participate in any meetings or committees that encourage all parties coming together for the best needs of the children. Thank you.
Thank you for your testimony. Our next meeting is Wednesday, the 14th, same time and same location. With that, members, meeting is adjourned.